The relationship between the representative, the law guardian, and the parents can differ depending upon who the law guardian is, what his or her practice is, and what the courts want. But it's my practice, and most law guardians' practices, to meet with the parents, both individually and with the child, their child. It's also important to sometimes visit the child's home. Sometimes I'll meet with other family members, grandparents who may live in the home. Sometimes I will meet with a nanny or babysitter, a teacher. I try to get as much collateral information as I can, depending upon whether or not I think it's necessary. Well, the best case scenario was when I was able to settle a very high conflict divorce where the parents were extremely verbally abusive to each other and about each other. And I was able to convince them to agree to a parenting time arrangement that was requested by my client and was actually acceptable to both parties. And so litigation that was going on for about 2.5 years was ultimately resolved without having to go to trial. So that was one scenario. Recently, I settled a matter as a law guardian where it was a post-judgment case. The parents had been divorced for a number of years, and they were not in agreement about what their 13-year-old son should or should not do. And I was able to meet with the child, meet with the parents, meet with the child's therapist, the therapist for the parents, and I was able to ferret out rather quickly a resolution for what the child was going to do in his summer and what he was going to do during the year and how frequently he was going to continue to see both parents. And that meant that this couple, who had litigated custody in the past, so they knew what trial was about, did not have to litigate. And it meant that this little boy could do his summer program and really do both things that his parents wanted done, and I think have some emotional release and relief from the pressures he was feeling as a result of them arguing about what he should or shouldn't do. The worst case scenario was also a case not too long ago where there were two teenage boys. Both of them, their mother claimed that they did not want to see their father. It was clear to me after discussion with both of them that they really did want to see their father, and that this was an extremely hostile mother who was really overbearing, and they were afraid of her. I did many attempts. In fact, I actually supervised a parenting time session with the father. It went really well. After the parenting session, the younger teenage boy accused me of wrongdoing, of pressuring him. I realized, and the court realized, that it was his mother who was influencing him. The older teenage brother, however, continued to insist that he wanted to see his father. So I convinced the court that he should be able to see his father. But the younger boy, the court felt that it would be inappropriate and it wouldn't be constructive to force a 13-year-old to see his father, even though he agreed that he thought it was because of the enormous pressure from the mother. But since the mother was going to maintain custody, the father wasn't asking for custody, he felt that it would be wrong to insist that the 13-year-old boy see his father. I disagreed with that decision, and that was, to me, a very sad day for that little boy and his family. Actually, children are amazing. When you meet with them, usually they're very savvy. They know the differences in their parents' personality and temperaments. They're very much aware of the issues, and they have an opinion. And most times, their opinion is that they want to spend a fair amount of time with both parents, and they want to figure out a way how they can do that. And sometimes they will tell you that they feel a little bit uncomfortable with expressing this because one parent or the other may not be so happy about what they're going to say. And how I get them through that is I meet with them. Sometimes we go out and we get soda, we go to the park, we sort of try to, interact in a way that's more comfortable with the child. We email each other, talk on the phone, and, it takes time before a child feels comfortable enough to be willing to disclose to you. And the other thing is that they understand that they have attorney-client privilege. I am not permitted to reveal anything about what they say unless the client gives me permission. So that's how I do it vis-a-vis learning about the child. Sometimes I do it almost in a negative way, like that little boy that I told you about who said he didn't want to see his father, but I really observed that he did want to see his father. I realized in talking with him that the allegations that he was making against his father were exactly, almost word for word, the allegations his mother made. So much so that I thought it was rehearsed. And in addition to that, he was talking about memories that he had when he was really too young to have those memories. So in fact, it was very similar to what the mother had reported, but at a time when this little boy wouldn't have had a memory of it. So that, in some ways I did it in almost a negative inference. I decided that he really was intimidated by the mother by virtue of the way he was reporting to me what he found, what he didn't like about his father and why he didn't want to visit his father. Well, sometimes one parent doesn't really want the divorce and is extremely sad, depressed, angry, and they don't realize that they turn to the child for emotional and psychological support. They sometimes talk about the divorce. They sometimes talk about perhaps something bad that the other party's done to them, like adultery, an affair, financial issues, and they talk to the child as if the child is an adult. No matter how old the child should not be made the third party with those problems. That parent needs to find another resource, a good friend, a therapist, to talk about these kinds of issues and not burden the child. Because the child will tend to want to protect the parent they see as extremely injured, and that will affect the relationship they have with the other parent, good, bad, or indifferent. It's often bad to constantly check on the other parent to see if the child is doing what you want the child to do when they're in the custody and care of the other parent. So for example, I recently had a case where one of the parents, when the child was with the other parent, would call to find out, did you brush your teeth? What did you eat for dinner? Did you do your homework? Has mommy or daddy helped you with your spelling? Kind of a third degree, where the child who is really with the other parent, to be with that parent and to interact with that parent, first of all, is being interrupted, then is being treated in a negative manner by the then non-custodial parent, and also it's a tremendous amount of anxiety for the child to have to worry about whether or not she tells the truth to the other parent, she alibis for the parent she's with. It's wrong. It also makes the parent who has the child usually furious, because the assumption is, and the inference is, that they are not sufficiently adult enough and competent and capable enough to parent their own child. And it only leads to animosity, bad feelings, and it's the kind of thing that creates custody litigation, even though one would think it's just a simple issue. It's not such a simple issue. I think the parenting time for each parent should be relatively sacrosanct. One phone call during that period of time is fine, but to constantly call and interfere is not a good thing. I think talking badly about the other parent in the presence of the child is the worst thing you can do in a divorce. I think a subheading of that is telling the child, for example, in a negative manner, in a negative tone of voice, oh, you're just like your father, or oh, you're just like your mother, when it's very clear that the the observation the parent is making isn't a positive one about the child, it's a negative one. And I think that really makes the children sad, it makes them depressed, they have nowhere to turn, and they're burdened by it. Because it means that the child, first of all, looks towards the parent, feels that there's some quality that they have that's bad, and that parent is not going to love them because they have this quality. So it really is very upsetting and very threatening to them, and it's something that should be avoided, I believe, at all costs, unless you're comparing them in a positive way. Well, I think it's possible to determine it based on what the child is saying. For example, sometimes how the child acts. That's one way you can figure out what a child wants, depending upon their age. I think an older child, for example, a teenager, certainly should be asked about how much time they want to spend in both houses and under what circumstances, and that child should feel comfortable expressing his or her opinion. I think that another way to handle it is if the family is in divorce counseling. Divorce counseling can be a situation where not that you're going to reconcile, but that a therapist is retained to meet with the mother, the father, and the child to see if he or she can't work out what it is what is best for the child, or the family can agree on, or what the child wants. Sometimes the child needs their own advocate, but that should be only in the last resort, because if you are paying attention to your child, if you're reading the psychology books, if you're looking on the internet for information about what's best for children in divorce, I think you will discover that sharing the time as best you can and as reasonably as you can with the other parent, sharing the holidays, sharing the birthdays, sharing the parties is obviously the best case scenario, and it will at least give your child an opportunity to have a positive outcome from the divorce and not a negative outcome.